Yes, let me get to Noah Adamtey, who is law lecturer at GEMPA and also serves as head of research to the current Constitutional Review Committee. And so for you, Noah, I want us to get to this whole conversation about separation of powers and, Article 146. Now, it's been in the conversation for some time now. There are those who've questioned the determination of a prima facie. There are those who've questioned how cases are supposed to be in camera or, not held in public domain. Do you think that that whole article warrants some amendment to offer the judiciary more protection?
Okay, thank you very much. And thank you also to CDS and then to the listeners who have joined us today. So that is a very important question in my view. I think Article 146 should be changed. It requires serious amendments. But I have to also state that the view that Article 146 should be amended is not necessarily because of what is going on now. I'm saying that because we could have a situation where the incumbent government will be complying with all of the constitutional standards required in the removal of a chief justice. But the procedure in itself, inherent in the procedure, is a flaw that still needs to be addressed. So when I say that Article 146 needs to be amended, I'm speaking about the fact that there is a possibility that it will undermine judicial independence. And not necessarily because, as it's being used now, it actually undermines judicial independence. So when you look around, first and foremost, I like that my senior Benjamin mentioned the Committee of Experts report. When you look at the Committee of Experts report to the 1992 Constitution, they recommended a style for the removal of a chief justice. In my view, I think that style should have been adopted at the time the Constitution was promulgated. So they recommended from the Council of States that the Council of States itself should have some form of committee within it, which is a judicial committee. Now, that judicial committee is comprised of judges, is comprised of someone from parliament and other persons who do not belong to either the executive or parliament. And when there is a petition for the removal of the CJ or any person, the Council of State has a role to play within it, but specifically for the removal of the Chief Justice, the committee that will be set up. Actually, the prima facie case is determined by that judicial committee, and the committee that will be set up is comprised of some people from that judicial committee, then some people who are justices of the Supreme Court, then some persons who do not belong to any of these institutions or organs. So you could clearly tell that from the perspective of the Committee of Experts, there was that understanding that the procedure for the removal of a justice, including the Chief Justice of the Supreme Court, can be influenced politically by the political branches and may be leveraged by them to impede the independence of the judiciary. So it was quite surprising that when the Constitution was being adopted, that style was put aside, and then we adopted a position where almost throughout the procedure for the removal of the Chief Justice, everything is almost dependent on the president as we have it now, particularly following the decision that was given by the Supreme Court in Francis Ejechu. Now, we look at the current position now. Any person can petition for the removal of the Chief Justice. Now, the petition goes to the president. Based on Ejechu, the president will then decide in consultation with the Council of State whether or not there is a prima facie case. But the same Supreme Court has interpreted the mean of in consultation with and on the advice of in their decisions to mean that the president is not really bound by the advice or is not really bound by the outcome of that consultation. Now, what that means is if the president consults the Council of State, whatever the Council of State says, the president is not necessarily bound by that. So the president may go ahead and say that there is a prima facie case established, even when the Council of State and the members thereon do not really think that there is a prima facie case, because they are there just to consult with the president for that outcome. Now, when that happens, the president, together with the Council of State, will then also establish the committee that will hear the petition. The question then is, who determines the people that will compose of the committee? Should it be person that the Council of State suggests, or should it be people that the president himself puts forth? Again, here the president is consulting the Council of State. So the stronger arm in that deliberation. So if we appoint 5 people, it is very possible that the president may have influence or serious influence in appointing all 5 of them. The only time the president seems to be bound is when the committee established starts its work, and at the end, they recommend the removal of the Chief Justice or whatever recommendation they make. That is the only time the president is bound to comply with that recommendation. So we see that what Article 146 gave us is a procedure that the president can control from the beginning to the end. So if you do not have a president who exercises self or professional restraint to allow the Council of State to play a pivotal role in that discussion, to allow the Council of State to play a pivotal role in establishing the prima facie case and in composing the committee, you risk having a situation where any flimsy petition can go to a president and it will be carried through to a committee set up with his huge influence that will recommend the removal of the Chief Justice, and the Chief Justice stands removed. And that is why it is so crucial that Article 146, as it stands now, need to be amended to at least provide some security to the Chief Justice or to even other members of the judiciary, especially the justice of the superior courts, when cases are brought or petitions are brought for their removal. So that would be my view on Article 146 as it stands
this
now.
Committee that you say should, focus on these things, just a way of clarification, what should be the constitution of that committee?
Yeah, so in my view, if Article 146 is to be amended, and this is not the view of the Constitution Review Committee that I'm researching for, this is my personal view. I think that, as I said earlier, we should go back to the proposition that was made by the Committee of Experts. And that will also require a refashioning of the Council of State as we have it now. You see, when you look at our Constitution, after creating the Council of State, it allows the president to appoint 11 members based on the president's own discretion, whoever he decides to appoint, to be members of the Council of State. Now, the purpose of the Council of State, as it was envisioned by the Committee of Experts, was so pivotal that, in my view, allowing the president to appoint 11 people onto that committee dilutes the integrity of that council and allows those people, even when the council is supposed to vote to take decisions, the president will still have an influence in the in-house deliberation of the Council of State itself. So I think that, for one, we must refashion the Council of State. We must make sure the Council of State is composed of experts in some technical fields that are relevant to provide the good advice they need to give to the president. And then persons from important areas or some relevant stakeholders in our society, like the chiefs and all of those people, can be maintained there. Then if we have a very robust Council of State, we should then create a judicial committee within the Council of State. That necessarily need not be judges. They have to be lawyers who are very independent, and then persons who qualify, for instance, to be on the Supreme Court based on their experience in practice, to be on that judicial committee. Then when there is a petition for the removal of any person, that committee goes to the president. Then, like the Committee of Experts recommended, the president does not play any role in the determination of the prima facie case. The president is simply a conveyor belt who forwards the petition to that judicial committee. That independent judicial committee within the Council of State determines whether or not there is a prima facie case. Then they provide their determination to the Council of State as a full house, and that plenary body then constitutes a committee. That committee will then look into the allegation, the petition against the Chief Justice, and then they will come out with their finding, which then the president must act upon. So from the onset, the president's role is simply receiving the petition and then passing it on to an independent body. And then there was a second independent body that would also look into the petition after it has passed the prima facie stage by the Judicial Committee. I think this will provide a more protective cover to the judiciary than we have it now. So I think it goes back to a refashion of the Council of State. If we leave the Council of State as it is now, and the president has to consult that Council of State, and he has those 11 people that he self-appointed there, and now the president and then his political party will also have the chance of sponsoring people to participate in the election to the Council of State. The president then has a greater control of the Council of State than ordinarily we had intended it